The proceedings in the Rafic Hariri trial have begun, where the judgment on 4 men allegedly involved in the killing of former Lebanese PM Rafic Hariri and 21 others in a 2005 bombing will be read out. The killing was a watershed moment for Lebanon and gave rise to rival alliances that shaped Lebanese politics for years afterwards.
There were no smartphones in Lebanon in 2004 and 2005. The case was entirely circumstantial. The only exceptions were when witnesses testified as to where they were at a particular time, and the cell site data of their mobile connections matched this. This was particularly important in pinpointing Mr. Hariri's locations when he was under surveillance. His bodyguards used their mobiles, and the media covered his appearances. His office kept records of where he went and when, and of his numerous trips out of Lebanon. Putting these things together, it is possible to conclusively establish where he was and whether any network mobiles were nearby at the same time. If they were, the trial chamber could then consider whether the network mobiles were conducting surveillance of him, or, alternatively, if their presence there was simply coincidental when compared to where they were before and afterwards. For example, if Mr. Hariri visited a church and the network mobile started connecting to cells covering the church, or he went out to lunch and the same thing happened, or he travelled to his Fakra village about 50 kilometres north of Beirut in the Furaya area, and the network mobiles were suddenly connecting to cells along the route on his way there and back, patterns emerge. And it is the consistency of these patterns that allows conclusions that these things are beyond coincidence. The trial chamber heard evidence of all of these facts. What has just been said is a way of explaining it in a simplified manner for the purposes of this pronouncement. It's explained in much greater detail in the summary and in the judgment. The trial chamber heard a lot of evidence about whether the prosecution's cell site evidence was reliable. The trial chamber has concluded that it was sufficiently reliable to use to establish where mobiles generally were. This is reliable enough to establish the patterns of travel of multiple mobiles. For example, if they travel in the same direction in a manner in which co-location is possible, and the sample size is sufficiently large to draw this conclusion, meaning the more calls, the longer the period, and the more they travel. But it is nowhere near 100% reliable. But this is not necessary to establish these patterns. It becomes more important when precision is needed to place someone at a certain place, like a particular payphone or a mosque or a tree, at a specified critical time. If someone is alleged to have used a certain payphone at a particular time, and the only evidence of this is that their mobile connected to a nearby cell at around that time, this is far more difficult to prove. The prosecution and defence used what are called call sequence tables to show the call connections, cells, mobiles, and texts. These are extracts from the call data records of the telecommunications companies put into tables. Without these, the call data records are just strings of incomprehensible numbers. Turning to a fundamentally important matter, the standard of proof. The prosecution must prove the guilt of the accused beyond reasonable doubt. The accused are presumed innocent until a verdict of guilt is entered against them. The trial chamber considered every crime and charge against each accused individually, determining for each whether the evidence establishes beyond reasonable doubt all facts indispensable to a conviction. The trial chamber judges voted separately on each charge in the indictment, and also, if necessary, to make separate findings on whether each accused was guilty as charged. The verdict here is unanimous on each count. The trial chamber has assessed each piece of evidence in the context of all related evidence. Taking this approach is particularly important in evaluating the prosecution's telecommunications evidence. The evidence against the four accused, as said earlier, is almost entirely circumstantial. It is only from reviewing the relevant facts in their entirety that a chamber can see patterns that could potentially emerge, from which conclusions could be drawn that they are so striking as to be beyond coincidence, and hence provide proof beyond reasonable doubt of facts that are indispensable to a conviction. The trial chamber is also acutely aware of the difficulties in attempting to assess the reliability and credibility of witness testimony, especially in an international setting, through interpretation, and many years after the attack on Mr. Hariri, in evaluating the evidence of each witness. Turning to the political background and context to the attack. The trial chamber received extensive evidence from the prosecution and also the defence of Mr. Hussein Hassan Anessi concerning the political and historical background to the attack on Mr. Hariri. Mr. Marwan Hamadeh, Mr. Walid Jumblat, Mr. Fouad Signora and Mr. Jamal Sayed and other politicians and Lebanese officials testified about the events leading to Mr. Hariri's assassination. The trial chamber, it is stressed, has no role as a trial court in either writing or correcting any version of history that witnesses or anyone may have urged upon it. Its role is to decide only whether the four accused are guilty beyond reasonable doubt of any of the charges on the indictment. The attack on Mr. Hariri, however, did not occur in a political or historical vacuum. The trial chamber cannot ignore the background to the attack as providing a possible motive for it. Motive, though, is not a legal element of any of the crimes charged. The assassination by car bombing of a prominent politician who had recently resigned as the Prime Minister and was preparing to contest the next parliamentary elections was undoubtedly a political act. Understanding the political background to the attack gives context to why Mr. Hariri was targeted in this manner, but only as it relates to whether the accused on trial are guilty of any counts charged on the indictment. The evidence showed Syria's overwhelming political, military and economic dominance in Lebanon after the end of the tragic civil war. Opponents of the Syrian presence included Mr. Jumblat's Druze political faction, Christians and members of Mr. Hariri's own future movement. Mr. Hariri's political allies vocally supported a United Nations Security Council resolution, number 1559, which, in September 2004, called for the disarming of militias in Lebanon and the withdrawal of foreign troops from Lebanon. One militia was Hezbollah's. The soldiers were Syrian. The
verdict is being handed down by the Special Tribunal for Lebanon in Hague in Netherlands. 4 Hezbollah members have been tried in absentia for the assassination of the billionaire-turned-politician in the massive 2005 car bombing in Beirut, which also killed 21 others. Hariri was an opposition MP at the time of his killing. The killing became a major catalyst for change in Lebanon. It sparked the Cedar Revolution, which forced Syria to end its decades-long occupation of Lebanon. Meanwhile, Iran-backed Shiite group Hezbollah has once again denied any involvement in the killing of the popular Sunni leader, saying that its members are being made scapegoats. Fingers have also been pointed at Syria. This as Hariri had been demanding Syrian troop withdrawal from Lebanon. Hariri's son Saad Hariri, who also served as Lebanon's Prime Minister, said that the verdict will bring closure to the Lebanese people. The verdict, which has been overshadowed by the August 4 Beirut blast, is expected to create more divisions in the politically and economically unstable country.
And issued calls for the end of Syrian domination of Lebanon. These occurred in September and December 2004